Hello and welcome to NewsClick. Today we have with us Dr. Satyajit Rath of National Institute of Immunology, and we are going to discuss the US Supreme Court judgment on human gene patenting. Satyajit, two parts to this judgment. One is that it is accepted that natural genes cannot be patented. It comes under what is called the 101 exception, which is the natural laws, etc., cannot be patented. But it has talked about something called cDNA, which is patentable. We'll come to that issue later. The first part, the human genes cannot be patented, a big advance.
If you look at it, it's a huge change, not simply for the issue of gene patenting. It is, of course, a major issue for gene patenting, no question about that. But the wording of the Supreme Court judgment almost directs patent authorities to go beyond genes and to say that simply discovering, isolating is a natural molecule is not sufficient for patentability under the USC 101 clause. Now, I can argue that that is true of pretty much any drug molecule that is discovered from nature, from plant sources, from microbes, from seaweed, from whatever. After all, a very large proportion of our drugs come from natural product sources. The breast cancer drug Taxol is a perfectly good example. So it now becomes possible to make the argument that it's not simply gene patenting that has been invalidated by the US Supreme Court, but all naturally occurring molecules of any utility in and of themselves cannot be patented. I'm not sure that this is how subsequent litigation, which is inevitable, is going to read it. But the current wording of the Supreme Court judgment opens this door.
Even if we don't go to that door, through that door, and I think that Supreme Court's intention was not to be so revolutionary, because they have discussed during the oral testimonies various things, and one of these things was, of course, a plant extract. But looking at the gene patent which has been disallowed, which means that all genes will not be patentable, that may not be such an important issue, because gene patenting is set really is going to expire. The genes were discovered before the Human Genome Project came out with the results. So roughly another 3 years, these are all going to expire. But the important part of it is also that any information naturally occurring in such substances would not be patentable, which was at the core of the gene patenting, because in some sense it was the information coded by the gene, and this means that it would also be microorganisms found in nature, it would be all other natural occurring information which is there in genes, as well as segments of genes. So a whole bunch of things are not going to be patentable after this, even if we see it narrowly, not widen it as you are suggesting it could be.
So as a matter of fact, the reason I bring up the wider implications is that the implication you're talking about, it's not clear that the Supreme Court judgment permits that. The Supreme Court has taken an extremely narrow view of what a gene is. It has said it's a sequence. It has not said anything about the information content implicit in the sequence, which is why it makes a distinction between that sequence and the cDNA, which we can talk about later, but the cDNA made from that sequence. Informationally, those are very closely allied, yet the Supreme Court has made a distinction between those. And the only real way of interpreting that is that the Supreme Court is not judging information content for USC 101 patentability conditionalities. It is actually judging the literal sequence. Nonetheless, it's not simply BRCA1 and BRCA2 that are at stake. Those will expire in 2 years' time, in any case. There are in excess of 3,000 gene patents out there already which are going to be affected by this judgment, because that many have been issued. It is true that pure gene patenting as a strategy, as a patenting strategy, has been declining over the past 10 years. I think 10 years ago, as many as 40% of gene patents were natural sequences. Today, less than 10% of sequences patented are natural. So, there is a decline. Nonetheless, that's a large number, and those are all patents that are far more recent. So, all of those are going to be affected in one way or another.
And also for naturally occurring genes in plants, animals, and so on. So the numbers are not just human genes, but also much larger than that. And also in the future, such patents would not be possible to be issued. We've really got back into the situation which the Diamond versus Chakravarti case really opened out, which is that it allowed artificially occurring life forms. In that case, it was an oil-eating microbe which Chakravarti had engineered. That the Supreme Court has really come back to this position, saying that artificial genes okay, naturally occurring genes no. And it doesn't therefore also strike down any artificial life form patenting, which the European Union had some problems with, and the Indian patent law certainly doesn't allow.
Yes, that's correct insofar as that goes. But as I keep saying repeatedly, I'm not sure that the US Supreme Court has understood in its judgment in a legally interpretable fashion what they mean by a gene. And that opens up all sorts of ambiguities where it's guaranteed that there will be litigation.
That's an interesting point that you're making. So let's come immediately to the cDNA.
Absolutely.
Issue, that it allowed cDNA patent to be argued as patentable. It didn't say that we see that there could be other challenges to it. It could be obvious, it could be not novel, and so on. So they've opened it out to saying that we are only talking about the patentability vis-a-vis 101. Absolutely. So in that sense, what is the difference between, first, what is cDNA for our audience, and what is the difference between cDNA and what Supreme Court has held to be naturally occurring DNA?
So here's the issue. In simple terms, cDNA is a sequence. So let me go back to the original gene in the gene that is naturally occurring and that is not patentable. Under ordinary circumstances, what you have in the human genome, the gene that codes for a particular protein consists of a sequence of individual chemicals called nucleotides, of which there are 4 kinds. And 3 nucleotides in a series codes for one particular amino acid in a sequence. So one amino acid after another, and therefore each 3 nucleotide set codes for one amino acid. That's how from a nucleotide sequence you can derive an amino acid sequence for a protein. That's by way of the central dogma of biology, as it is irritatingly called.
But first they have the DNA produces the RNA.
So let me come to the RNA. In your DNA, most protein genes are present as split pieces. You have, let us say, 10 amino acids, then you have a gap where there is a nucleotide sequence, but it doesn't code for amino acids. It has other functions. Then you have another, say, 30 amino acid code. Then you have a gap. So if you simply make RNA from this DNA, this RNA is also interrupted as in terms of its information content. So the RNA is processed and all the bits that have been transcribed from the DNA that doesn't code for amino acids are cut out, and a spliced RNA stretch is created, and that goes out, and from that as a template amino acids.
This is all naturally occurring in
this
the
is
body.
all naturally occurring. However, the spliced RNA is therefore a sequence that in the literalist rendering of the Supreme Court's view is not present in the DNA. Now, it's present as RNA.
But still a naturally occurring.
It's naturally occurring RNA. But you can take that RNA and you can build a complementary DNA. RNA and DNA differ in one of the 4 types of nucleotide chemicals that are used to synthesize them. The cDNA, therefore, in the Supreme Court's view, is unnatural, right?
It's done by laboratory technicians.
Because it is done by laboratory technicians and it is not present. The cDNA of BRCA1 and BRCA2 is never present in nature and therefore passes the USC 101 patentability criteria. That's the Supreme Court judgment, and this is why I'm repeatedly saying it's a very literalist judgment.
Now, what's the problem with this interpretation of the cDNA? Is cDNA really not naturally occurring?
So, the way cDNA is made is by using a naturally occurring enzyme. An enzyme that comes from some bacteria, and similar enzymes, they are called reverse transcriptases because they make DNA from RNA rather than making RNA from DNA. And a number of microorganisms use this enzyme for natural processes, right? So, clearly, making DNA from RNA templates is not unnatural.
All retroviruses do that.
All retroviruses do that. How accurately they do that is a whole different problem altogether, but retroviruses do that. Many other organisms also use reverse transcriptases. The Supreme Court, therefore, is not saying that there is no such thing as cDNA in nature. The Supreme Court is saying something far more specific. They are saying there is no BRCA1, BRCA2 cDNA in nature. And because there is no BRCA1, BRCA2 cDNA, it is a laboratory technician creation and therefore passes 101. And which is why I am coming back to my original point that the Supreme Court has dealt with the sequence as though it is a literal sequence rather than a sequence carrying information. That the informational content of the RNA being transcribed to DNA, it has come from one form of DNA, it has come to a form of RNA, it goes to another form of DNA. This is all part of a natural, predictable process. If you simply look at it as information content, is an issue that the Supreme Court, the US Supreme Court has not taken into account.
Most of the scientific researchers in the area have called it that they would really fail a student which produced a report like this. And Judge Scalia actually made an almost similar point, saying he agrees with the broad judicial understanding of what's being given as a report. But the biology of it, he thinks that, is bogus, that he neither understands it, and it literally implies the judges haven't understood it either. So, looking at the science of it, it does seem that the science is very dicey or sketchy, if you will. And it seems to be that the intention is to protect the biotechnology industry in the United States, which has made a lot of investments, and the fear, the argument that this would really affect innovation, and also the fact the Obama administration really also presented the same argument at the court, saying cDNA is patentable, DNA is not patentable. So, do you see this as really a victory over economics, over science?
Well, as I said, if you treat it in the literal sense that the Supreme Court did treat it, it sort of hangs together consistently. The real difficulty is we tend to forget when this comes into the domain of public discourse that, to be fair to the Supreme Court, this comes hard to me, but to be fair to the Supreme Court, they are really talking about USC 101 conditionalities. They are not judging on other matters. And consequences might turn out to be very odd. So, for example, there are anecdotal stories floating around that Monsanto is very happy with this judgment. So, why is Monsanto happy with this judgment? Monsanto, if apocrypha are to be believed, Monsanto has reason to be happy with the judgment because Monsanto is not in the business of selling genes. Monsanto is in the business of selling seeds. And what Monsanto does is tinker with the genome of crop A, crop B, crop C, and engineer it and sell it. Now, if people could start and continue to patent genes from the crops that Monsanto was tinkering with, Monsanto's ability to take crops and to tinker with them
would be limited.
Therefore, this is a judgment that Monsanto sees as to its advantage in commercial terms. It's not at all my suggestion that this is what Monsanto thinks. I'm simply saying there is apocrypha out there that says this, and it's an interesting light, regardless of whether it is true or not, on the twisted ramifications that the judgment will have when it actually collides with the real world of commercial strategization of multinational.
It's clear that a certain section of scientific community, researchers, and probably even companies were unhappy with the idea of genes being patented because that forbids further research and makes it the prerogative of just one company. So one can argue that really in this larger sense science has triumphed in opening it out to certainly
no question
more.
About that. But apropos of that, let us keep in mind something that we have not won. For 17 years, 16 years, whatever it has been, Myriad has held the BRCA1, BRCA2 gene patents, which means that they are the only people who have been collecting information on BRCA1, BRCA2 mutation distribution in communities, right? They've therefore built an unparalleled database of information.
Nobody has
This
access.
database, nobody has had access to because they held the patents. Today, the patents are invalidated. But is the database still their property? And if it is, how do we resolve this peculiar little situation that has emerged, which says that they have collected the database under an exclusive claim that actually has never been enforced according to the Supreme Court? I understand that we don't go back retrospectively and penalize and so on and so forth. But the database is still information that's available, and it is certainly in the public interest to have that database become accessible. There are many fights that we have not yet won, even though having the US Supreme Court come down very clearly saying that gene sequences fulfill the exclusion condition of USC 101 is a victory in and of itself.
So a limited victory, but nevertheless a victory.
Oh.
And for the future, lots of fights still remain.
And I will therefore come back to my original point once again. This is a victory that people in the public interest, people fighting in the public interest, activists in the public interest, should be using to apply to non-DNA naturally occurring biomolecules, because that will open up a whole new category of litigation. It's not that the pharma industry is not aware of this. A very large amount of the concern in the pharma industry is precisely on this matter. And there is no reason that this should not be held to the test of litigation.
Well, first congratulate American Civil Liberties Union for taking up this case, and Public Patent Foundation, the two organizations who fought it, and the scientific community which stood with them in order to break open this case. And I think we need to see much more of this in the future. Thank you very much, Satyajit. We'll continue to watch this area because I think this is now going to open out in different ways, even though life form patenting in the US still continues and artificial genes can be patented, as Monsanto, as you said, is delighted in this part of it. That still continues, which is not possible in India and in many other countries. Thank you very much. Hope to see you again.
Thank you.